The court has looked at all the charges stroke counts leveled against the accused person hearing. On the face of them, particulars reveal an offense under Section 313 of the Penal Code. As to whether the prosecution has evidence or not to prove those charges, that is an issue that will be determined after the prosecution has presented its evidence. Unfortunately for this court, it does not have the benefit of the evidence or even with the witness statements to be able to determine whether the case by the prosecution has any legs to rely on. Further, it is now settled law, and I will not be able to go into the very many decisions that have been made, that the existence of a civil suit stroke claim does not operate as a bar to criminal proceedings. Each case must be looked at in its own circumstances. In any event, there is no evidence that all the complainants in the charges hearing have civil suits or claims against the accused persons. The prayer for rejection of the charges under Section 89(5) of the CPC is thus dismissed, and all the counts are admitted as properly before the court. The second issue relates to board terms. Under the Constitution, an accused person is entitled to be admitted on board terms as a matter of right, unless there are compelling reasons not to grant. The court will not belabor this point, as the provisions of Article 49 of the Constitution are self-explanatory, and the superior courts have made various decisions while interpreting that section. With the Constitution being the guiding law on the issue of bail, the judiciary has further developed bail and bond guidelines, stroke policies. Therefore, in addition to accused persons' right to bail, the court is obligated to consider the rights of the victims, complainants, among other issues that are before the court. In this case, it is evident that there is a lot of interest. This is evident from the fact that during plea taking, the court was filled to capacity. There was such a big crowd. Secondly, counsel for the accused alluded, though in not very many words, there were some unwelcome incidences when the accused was first arraigned in Kiambu court. The fact that the complainants have also filed several claims at the small claims court further buttresses this position. Unfortunately for the court, and as clearly pointed out in the bail and board policy guidelines, the nature of our adversarial system is such that the information furnished to the court on behalf of the bail applicants is not always reliable. Further, because courts do not have systems for verifying such information, they may not always make fair and appropriate bail decisions. It may therefore be necessary for court to seek, in some instances, independent information if they are to make fair and appropriate bail decisions. The law, and indeed the board and bail guidelines, as well as the Constitution, recognize the role that other actors in the justice sector play in aiding the court at arriving at decisions as to whether to grant bond, and where such a decision is made, the terms of the said bond. In this case, it is my view that the court requires a comprehensive pre-bail report before board terms are set, if at all. Therefore, the upshot of the foregoing is that the court makes the following orders. Number one, the prosecution is directed to supply all witness statements and or documentary evidence it will be relying on in this matter. Number two, the probation and aftercare service department, DICA, is directed to prepare a comprehensive pre-bail report. Number three, this matter is allocated to court number one, which shall set board terms and or give further directions in this matter. If Monday 25th is convenient to you, councils, I'll give Monday 25th of September as the date for direction before court number one. I've looked at all your submissions, which my colleague will look at, and I'm of the view that a pre-bail report is important. Since I don't want to continue handling a matter which I've allocated to another court, I want to leave it that to the trial court to set its own bail terms. So kindly wait for court 1 on 25th of September. Whatever you have said is on record. My ruling will be on record. So she's perfectly capable of giving board terms. She has even been doing this more than me. So I'm sure she will be able to deal with what is on record.